All right, let's get started. Welcome everybody to a panel on insider trading, or as we've titled it, Reconsidering Insider Trading, Economic, Legal, and Moral Perspectives. I've taught on this subject for many years, as have other people here. It is universally the one topic that I think I can get the attention of every single student in my class. It's the stuff of movies. We think about it all the time. And
No, it's fine.
Okay, so much for the slides.
They're fine.
It's often sensationalized. However, there's, if you might imagine, quite a bit of disagreement about, among scholars, courts, enforcement officials, what actually qualifies as illegal insider trade, and that's what we're going to be here to discuss today. So we've got experts in law, accounting, finance, and we're going to talk about the pervasiveness of illegal insider trading, what defines it, how maybe it should be defined differently, and whether or not Congress should take action. We're going to learn that most of what we have defined by illegal insider trading comes from the courts and not actually from Congress, at least for a very, very long time. Here today is myself. I'm Scott Bauguess. I'm a faculty member in the McCombs School of Business. I also have to disclaim now that I'm an employee of Coinbase. I'm a crypto guy, so I'm doing both. And I don't engage in illegal insider trading. And I also have my co-moderator today is James Spindler. He's on faculty both in the McCombs School of Business and UT Law School. His background is securities regulation. He teaches on this subject quite a bit. And the two of us are going to toggle back and forth between our two main presenters today. We have Kevin Douglas, who's a professor of law at the Michigan State University. He also teaches on securities regulation, corporate finance, and importantly, if you look to see what his bio says, if you go to the website, he researches the moral principles that motivate organizational law and securities regulation. So he's going to say some controversial things to some of us, or maybe things that make a whole lot of sense. And he's going to lead off our discussion. He's going to do 10 to 15 minutes overview. And he's going to be followed by Dan Taylor. He's an accounting professor at the Wharton School. And he has, among some of his most impactful research, focuses on corporate transparency, accounting fraud, and insider trading. I've known Dan for a very long time. In fact, when I was at the SEC, I tried to recruit him and convince him not to go to Wharton, but he didn't listen to me. Good career decision. And he's since made a name for himself on some of these topics. So we're going to start with Kevin. He's going to do 10 or 15 minutes. Dan's going to follow, and then we're going to open it up for discussion. You have questions, James and I have questions, and we'll take the discussion where it goes. And another 70 minutes, we'll conclude. So, Kevin, it's you, and okay, we're back online.
Yeah, that was me. That wasn't a technical glitch. Thanks for coming out and taking the time to listen to this topic. I know everyone isn't hyper about securities regulation, even if there are movies out there that, like Wall Street, that sensationalize insider trading. And my claims might be the most sensational part of the talk, which is me trying to convince you that I think that our insider trading laws currently and the proposals that are being offered by Congress right now essentially criminalize certain kinds of economic inequality. And I'm not talking about criminalizing wealth inequality or income inequality. It's more obscure in the sense that they seem to penalize people who benefit from information advantages when trading in securities markets. They try to get everyone to trade at the correct price, which for me ends up meaning trading at the same price. And it seems like folks are trying to push for something that sounds like an equal opportunity to generate profits while trading in securities markets. But more details to come. I'm assuming most people don't have a legal background, and so I'll unpack some of these weird looking words. But the long and short of it is that I think that we can understand insider trading as kind of a distant cousin of something we'll call this fraudulent non-disclosure in breach of a fiduciary duty. And to unpack some of those words, anyone who's ever had a job is or has been a fiduciary. If you're an employee of someone, you are the fiduciary to your employer. Your employer is considered the principal, and what being a fiduciary means is that you have to use the assets associated with your fiduciary relationship for the sole benefit of the principal, your employer. That's what the duty of loyalty entails. And so imagine that you work for someone who happens to have a company car. If you want to use that company car on the weekend as an Uber driver to earn some extra money, if you did so without first getting your employer's informed consent, you would be described as having breached your fiduciary duty. Any income that you generate with the use of the car without consent is going to be identified as a form of unjust enrichment. The employer gets to take the money and keep it for themselves because you use their assets to generate the income, right? Despite the fact that you did the work. Insider trading is kind of sort of like that, but instead of a car, we're thinking about information. And so under the classical fact pattern, we can imagine something like the CEO of ExxonMobil knowing that the company is going to announce unexpectedly high returns reports at some point and buying the company's stock ahead of the announcement so that once the announcement comes out, the stock price goes up, he generates profits. Courts are going to say that he engaged in illegal insider trading under the classical theory of the crime, and they're going to say that they're going to describe it that way and say that he has breached the fiduciary duty both to the corporation and to stockholders. And they're going to say that fairness requires that he first disclose that information to the public at large before he's allowed to trade on the information. You have a similar case where, say, instead of the CEO buying the stock of his own company, he buys the stock of a second company. Imagine that Exxon is going to stage a hostile takeover of Chevron. The CEO knows this, CEO of Exxon knows this. He buys Chevron stock ahead of the announcement. Usually when one company takes over another, or any person tries to gain control of another company, they usually end up paying a premium for the target company stock. So if it was trading at 100 over the last 30 days on average, they're usually going to offer something like 125 or 150. And once the announcement about the attempted takeover is made, usually the stock price moves really, really close to the offering price for the takeover amount, right? So if the CEO were to buy a bunch of the stock ahead of the announcement, once the announcement is made, the stock price goes up, he generates profits. Courts are going to say that he has engaged in insider trading under the misappropriation theory. They're going to say that he has defrauded his employer of the exclusive use of their confidential business information, and that he's breached his fiduciary duty of loyalty to them, and that fairness requires that he first disclose to his employer, which would mean the board of directors, in our hypothetical, that he intends to buy the target company stock ahead of the announcement to the general public. You may have already been able to tell the ways in which I think that those two fact patterns make insider trading a distant cousin of the intentional tort of fraudulent non-disclosure. I said that under the common law approach, you need your principals, your employer's informed consent in order to be able to use their property to generate personal profits. Under the classical fact pattern, for the CEO to buy his own company stock ahead of the announcement, he simply can't. There's this thing called the disclosure or abstain rule, and you simply either can't buy the stock at all or you can't buy the stock until you tell the public the information you have that's going to impact the stock price. The fact that the tool of disclosure is disconnected from consent is the thing that makes insider trading case law different than the normal breach of fiduciary duty case law. In the second fact pattern, the CEO doesn't go to the board of directors and say, will you please give me consent to buy Chevron stock so I can make money based on the knowledge I acquired in this position that's really supposed to be used to help you successfully execute your takeover of Chevron. He simply says, look, I'm going to use this information to buy Chevron stock, so now you know I'm going to go do it and not face liability for insider trading. You might face liability for something else, but not insider trading under federal securities laws. That would be like, the company having a car and you telling them, I will use this car to earn money driving for Uber on the weekends. Now you know, and I'm going to go do it, as opposed to you having to get informed consent. So that's weird. It's the disconnect between disclosure and consent in the case law of insider trading that makes me think that it is effectively trying to criminalize economic inequality. The fact that under the first fact pattern, the classical theory, he has to disclose to the public at large, not to get consent from the board of directors, he discloses to the public at large, not even to get consent from the shareholders who are out there, but instead to make sure that the stock price moves to wherever it's going to move to before he buys or sells so that he doesn't generate a profit based on the information advantage. Under the second theory, you don't actually have a direct commitment to anything that looks like information equality. Instead, they make disclosure almost purposeless. You disclose to the people running the company that you're going to do this thing that's otherwise considered a violation of their property rights and confidential business information. And so you really don't have the effect of real property rights. Like if you were to steal trade secrets from a company, you don't get to just tell them, hey, I'm going to steal your trade secrets, and then go use their trade secrets in a second business without facing liability. So it's weird that disclosure alone would, to the owners of the information or the custodians of it, would be enough to avoid liability. There's a way in which we could say that what's happening looks like this one complicated version of it, but it doesn't really work. Second thing that makes it a problem that emphasizes the idea that what we're looking at is a commitment to economic equality. Oh, let me take a step back. In regular breach of fiduciary duty cases, let's say, again, you take this car, a company car, and you start driving for Uber, you generate the profits. Again, the profits are called unjust enrichment. They take it away from you, they give it back to the owner of the car, right? I'm gonna be simple and straightforward. I'm gonna treat the concept justice and as synonymous with fairness and injustice as synonymous with unfairness. Forget that guy named Rawls. And so in my mind, the fact that under insider trading law, fairness requires disclosing to the public at large, but under regular breach of fiduciary duty law or unjust enrichment theory, justice requires getting the informed consent of the owner of the asset. It shows a really clear disconnect in what's happening in these two areas of law, which I'll argue later is the fundamental cause of the confusion and where we should look for a solution. Last thing, again, remember the misappropriation theory case. The CEO of ExxonMobil is going to buy Chevron stock ahead of the announcement that ExxonMobil is going to take over Chevron. They're going to describing as defrauding ExxonMobil out of the exclusive use of their confidential business information. Usually you would want to get consent from that party, right? Well, in a handful of cases, you have a bunch of extra rules that have developed over time that essentially prohibit the information owner from consenting to the use of the information for securities trading. There's one thing called Regulation FD, fair disclosure, that prohibits companies from engaging in selective disclosure, disclosing to some market analysts important material information that others don't have, based on the idea that it's somehow useful to let some people know what's happening with your company and not others, despite the fact that this gives them a trading advantage in securities markets. There's also the idea that when you stage a takeover of a second company, sometimes it's useful to tell friendly investors that that's what you're going to do, so that they can buy the target company stock ahead of your announcement and actually be guaranteed to say yes to you when you go out looking to acquire the stock to take control. But that kind of activity is also restricted under tender offer regulations and this thing called rule. It doesn't matter. But it's a tender offer regulations targeted directly at insider trading, prohibits an activity called warehousing, which we can unpack later if you want to. There are other ways, but I'm going to jump ahead to talk about fixing the law. Let's say you buy what I just said. The law criminalizes a particular kind of information, particular kinds of economic inequality. Reform efforts that are going on right now are not really aimed at fixing that problem, but fixing other things, and I think that we could use this opportunity to fix two problems at once. One, I think the problem is fundamentally recognizing that we are operating with two conflicting, not just conflicting, mutually exclusive definitions of fairness are being applied in the law simultaneously by the people who are developing both the case law and the statutes and engaging in enforcement efforts. To the extent that the case law says that insiders face liability because they defrauded someone out of exclusive use rights of confidential business information, they're invoking commitments to fairness and justice that relates to property rights and would need something like using disclosure to get the right kind of consent to use your principal's property, their confidential information. But to the extent that they say that fairness actually requires disclosing to the public at large, they're not talking about property rights. If the information is valuable in part because it's secret and to avoid liability, you disclose to everyone in the world, you've undermined the value of the information. So that doesn't protect the rights and the information. It's doing something else. It's fostering a kind of information equality for all market participants. It's in some ways getting prices correct so that everyone can be trading at the correct price, but it's at odds with the protection of property rights, especially in confidential business information. I think to fix this, we need to decide whether consent is a defense against liability for insider trading or not. I think once we do that, if it is a defense against liability for insider trading, then we're choosing the concept of fairness and justice that's about protecting property rights and fostering individual welfare or individual flourishing. And if we don't, then we are fostering a conception of fairness that's about equality of opportunity in the securities markets, eliminating information inequality, and making markets efficient in the sense of trying to correct market prices of securities. If it were up to me, it's not, but if it were, I'd choose the property approach, make consent a defense against liability for insider trading, and let the information owners decide to let people use the thing or not. Everyone else here is going to talk about some other stuff, alternate explanations for what's going on, like the idea that what's happening is that we have to eliminate information asymmetries in order to allow the ordinary investor to have confidence in U.S. securities markets, that correcting prices by fostering information and making sure that prices fully reflect all available information is necessary to have efficient capital markets, and that's necessary to foster wealth creation society at large, or that a level playing field in securities markets is just a good in and of itself, but isn't exactly about economic equality. For lots of reasons, they'll explain those arguments better than I can, but because of what happens in trade secret law, what you call business opportunity doctrine and unjust enrichment case law, I'm convinced that those things don't outweigh a commitment to protecting property rights and in order to foster individual welfare.
Okay, Kevin, thanks. Now, Dan, what are your views on insider trading?
So I approach insider trading, so I should say by way of background, I have economics training. I do a lot of data work, so I'm much more of a data scientist and PhD economist, finance guru. I approach it probably a little bit differently than not just Kevin, but then I guess law faculty in general. The way that I think about it is that we all at some point come into possession of private information. And insider trading, at least the bright line between what's legal and illegal is how you came into possession of that private information. So one example is, let's say you come to Wharton and you take my accounting class. And now as a result of taking my accounting class, you can come up with a better model of a discounted cash flow, or you can come up with a better price estimate. And then you go and trade on that. That's technically trading on private information, or at least economists would say that, trading on private information that you acquired through costly processing and information acquisition on your own. That's considered legal. That's not what the law has no problems with that. The second way that you can come by information, and this is the misappropriation theory that Kevin talks about, is if you steal it, if it's not yours and you take it from someone. So, Kevin gave an example for misappropriation. There's a classic case that I like to talk about, the Capital One case, that I think is very relatable. There's two credit card analysts. They're in the Capital One office, and they get to see all of the retail sales in real time that come through Capital One's credit cards. So they see Abercrombie and Fitch's, they see Macy's, they see JCPenney, they see Burberry. They see all of these sales come in. As a result, that's access to private information. Information's not theirs. They take that information and they front run the company's earnings announcement because they have private information about what the sales is going to be, because they can add up all of the sales for Burberry and JCPenney and whatnot that ran through Capital One. Now, what's interesting about that is it's not perfect information about what the sales of the company are actually going to be, but it is information that doesn't belong to them. And they used it to extract what we would say would be private benefit, or they misappropriated information for their own benefit. So that's misappropriation. So that's the other way that you can come by private information. And then the third way to come by private information is, the classical case Kevin talked about. You're the CEO. Just by very nature, you have the board meeting. You learn that you're going to miss your earnings targets. That's information that you didn't have before, that you came by rightfully. You didn't steal it from anyone. It was just your job, and you were endowed with this information by virtue of doing your job. Can you trade on that before the earnings announcement? And the answer is no. There's something known as the disclose or abstain rule that Kevin talked about that says you have to disclose that information to shareholders before you can trade. So that's how I think about insider trading in terms of where you got the private information, and that you traded on. So a well-known defense, and you often see that's been invoked by several members of Congress that have been investigated for insider trading is that, yeah, I got private briefings on, the COVID relief and on the financial crisis back in 2008. But that's not what motivated me to go triple short the U.S. economy. I was watching, Fox News or CNN and seeing the information on the news. That's what's motivated me to go triple short the U.S. economy. And then the burden is on the prosecutor to prove that no, in fact, what motivated you was, this private briefing. But that's incredibly hard to do. So my perspective is that I think insider trading that we would typically think of, or that the average person would typically think of as unacceptable and impermissible by a capitalist society is quite rampant. So that's, I guess, Taylor's thoughts on insider trading.
So let's just do a quick survey here. Question I love to ask. Is there anybody here that's willing to raise a hand and say insider trading is fine, it just makes prices efficient more quickly, and we should be done with it? Anybody want to go with that? Nobody wants to take that? Okay.
Guy in the corner.
Yes.
Greg, okay, of course. Greg, thank you. So we have one person. Maybe I'll ask the first question, then I'll let James take a turn, but I'm wondering if property rights is the wrong way to think about it, because if we think about property rights and intellectual property, it's a productive asset. I know the secret formula to Coke and that sugary water actually generates me revenue, but information about the value of that sugary water, is that actually a property right in the same sense as we think about intellectual property right? And should we abandon the property right approach altogether? Am I crazy in thinking that?
You know?
Is that to me?
I think
Anybody.
so, but I can jump in if you want to.
Please.
There's this interesting thing that happens among law professors where we want to, how many law students in the room by a show of hands? One, perfect. How many people hoping to be law students one day? Okay. That's not gonna be helpful, but still, he'll understand what I'm talking about. There's this debate, there are different areas of law, and I think law professors often like to categorize other areas of law within the smaller categories. When you're a first year student, you learn about property law, contracts law, tort law, criminal law, and a handful of other things. You learn that a lot of policy debates are pushed by old school conceptions of equity, which is this very broad and complex system of thoughts, or it can be pushed by considerations, what are supposed to be practical considerations of economic efficiency or social wealth creation. What's gonna make society better off when it's tough for us to choose between rules. And that's the baseline. Separate and apart from that, there's trade secret law. And there's the idea that businesses often earn profits that they couldn't otherwise earn by keeping certain kinds of information secret, including Coca-Cola's recipe for their sugary water and exactly what goes into it to make it different than Pepsi, if you think it's different than Pepsi. And if someone were to one of their employees were to try and use that information, or someone were to pay some third party to steal it, the law would punish the employee and punish the thief. But because they consider trade secrets to be a form of property that belongs to the business. Some law professors think that we shouldn't think of it as a form of property and that we shouldn't think of what's going on in the case law as protecting property rights, because in some ways, the case law is enforcing contract rights between the employers and the employees who shouldn't steal it. And in other ways, it's enforcing broad commitments to equity and economic efficiency, to the idea that we're saying, hey, he produced that information, even if it's not property in the regular sense, we think somehow society will be wealthier if we punish people for taking it without the consent of the person who we say controls it but doesn't own it because it's something different than property. I say we law professors often make the mistake of wanting to fit different complex bodies of law like trade secret, business organization law, patents, and something else into just one bucket, like contracts, property, tort, or something, as opposed to in a way that folks are trying to say, is a platypus a mammal or some kind of a bird because it lays eggs and it has a bill, but I guess it has memories. I don't know. It's like we're trying to do what kind of species or category of species it is, and I think it would be better if we were to recognize, not try to look at these areas of law, property, contracts, and something else as species-like level categories with taxonomy, but instead look at it as anatomy. Like these are organs that make the thing work. So lots of different areas of law rely on both on all property, contracts, torts, and a whole bunch of other things. So does trade secret, so does insider trading, so does sec reg, so does patents, copyrights, et cetera, et cetera, et cetera. So we don't have to get rid of it and stop calling it property.
So I have a question for the law professors. So I've been thinking about, preparing for the panel and the role of insider trading and property rights. Suppose that the firm, when the firm is founded in its founding documents, decides that it wants to contract with the CEO. And they're going to contract with the CEO, and the contract basically says, Mr. CEO, you can engage in all manner of trading. If the information is property, we're giving it to you. We're assigning it to you. All information, rights to trade on the information is yours. And in exchange, we're not going to pay you $10 million cash. We might only pay you, $2 cash. But now you have the rights to engage in insider trading. So that would be a property transfer because you're giving the right to the information. Legal, illegal, can't happen. What law is being violated?
You got that, James?
Give him an easy one.
Well, I think I think it's something of an open question as to whether you could actually get away with doing that. I think SEC enforcement would take a dim view of this,
Correct.
right? So the original, if you go back to the 1970s and look at how the SEC went about enforcing what they viewed insider trading law as being, they viewed any non-public material inside information as being subject to the insider trading disclose or abstain rule. So, if you got satellite data about where the shoppers
Right.
were showing up, and you use that to essentially get an edge on the marketplace, the SEC back in the 1970s would have said, no, you can't do that. That's insider trading, right? And that's actually, that sounds kind of ridiculous in a way in the modern day when we've gotten used to the status quo. But there's actually a fairly good economic argument for that. And the economic argument for it is that if you have a problem of asymmetric information in the market, if you have some traders that are smarter or better informed than other traders, then the run-of-the-mill average Joe type of trader, like me, who doesn't know anything, wouldn't want to participate in the markets, right? And if I'm necessary to the markets to provide liquidity and so that all these good things happen, like IPOs and liquid stock trading, then my staying out of the market has negative effects for the economy, right? So that's actually a kind of a cogent opinion from the SEC. Now, to turn this sort of into a question about, I think, the property rights view of this, right? Which I'll throw back at one of you three. In my view, the status quo is just fine. Currently, the SEC is or SEC enforcement. I should distinguish that. SEC enforcement is very different from the rest of the SEC. But currently, SEC enforcement is rather hot and bothered because they've lost a number of insider trading cases. They've come out with a recommendation, or rather one of the former, it's called the Barara Task Force. I may be mispronouncing that name, but someone can correct me here. And essentially, it's a number of former SEC personnel and federal prosecutors that are trying to make the law more clear so that prosecutors can win cases. And I think that's one way of viewing what they've done, because they're upset about these losses. But the status quo currently, or arguably at least, isn't all that bad. Insider trading might happen, but it doesn't happen in very large volumes, right? It appears to happen in a number of mergers and acquisitions, but the volume of trading isn't that high. So arguably it isn't eating very many of those profits or those abnormal returns that would have gone to other uninformed market players, right? If you were to move to Kevin's property rights view, where you allow the CEO to go and make all the trades that he or she would like, And maybe you even go further than that. You extend the CEO a line of credit so that he or she can go out and make not just $1 million trades, but $100 million trades. Yeah, now you can do a management buyout based on private, right?
Happens.
Now you would be moving from the status quo where insider trading is relatively small to a world where not only does insider trading happen a lot, but the dollar volumes at play are huge. And so where now you have information asymmetries or better informed traders that are now absorbing all of those good news events and really tipping the table enough that you would have people sitting out of the market and all the sort of bad things that we think would accompany that. So I guess turning that question around, what's so bad about the status quo? And wouldn't moving to something like a consent-based system be at least kind of a dangerous thing to do?
I'll jump in. So your response to Dan, can I know you, Dan? Mm-hmm. Your response to Dan is no licensing the CEO to trade on inside information, and definitely not while also giving him a line of credit that lets him expand his possibilities. I have two problems with the status quo. One, a rule of law problem in that I think we're explaining and mislabeling what's happening with the prohibition on insider trading. It's often described as a property thing. Like, I think the property thing would involve what Dan described as creating the opportunity for the information owner to license or consent to third parties trading on the information, whether it's to the CEO so that they can reduce his salary, or whether it's to their suppliers so that they can pay less in cash for whatever widgets they input into their products, right? Whoever it is, you might be able to reduce your cost of running the business by licensing other people to trade on your information in securities markets. It's a valuable asset, and now it's being sidelined because of a bunch of rules that don't want trades happening in securities markets with information asymmetries. So it's bad because we're mislabeling the thing, saying we're protecting property rights, but it really undermining the usefulness of property rights, undermining the use, and to the extent that a defense is possible, it includes sharing things with everyone in the world, which undermines the exclusivity, which undermines the use, because it's related. So mislabeling, that's bad. And it's bad because right now reform efforts are happening. And the Barara task force tries to keep the status quo going, and they describe it as a commitment to property rights. They acknowledge that some people have raised the idea that you should allow information owners to license third parties to trade on their information in securities markets, and because of their commitment to property rights, they're not willing to do it because they don't want the information owners' property rights to be violated. But you just said you're not going to let them consent to it. If they consent to it, there's not a violation of their property rights. They also bring up this idea, and so I think the mislabeling is wrong, and it misleads the voter, and both in Congress and in the general public, about what we're doing with the law. It seems like we're protecting property rights. We're really fostering different kinds of economic equality. To the question of this, what we need to do to foster the confidence of the ordinary investor, because of Coca-Cola and their trade secrets, because no one says to themselves, if they don't tell me all the key ingredients, I'm not going to buy the soda. Like, trade secrets are used in a wide variety of places in life, and folks don't say, if they don't tell me everything about their products, I'm not buying. So to me, it just, while I know that there are well-respected theories out there that say that information asymmetries drive people away from the marketplace, I don't think there's any observable facts that support the idea. On top of that, trade secrets are used in securities markets. Over the last 10 years or so, at least 2 people have gone to jail for stealing the trade secrets associated with high-frequency trading. People have taken the programs that were being used at Goldman Sachs and at least one other company and have been sentenced to 7 years in jail for taking that stuff and trying to use it to do their own trading. There's this weird thing where we are somehow okay with economic inequality when it's like a capital inequality, technology, money, skill. We're okay with it when it's a few other things, but when it's information that's specifically about the price movement, then we have a problem.
But that's not, just to interject a second, that's not really, in my view, a property right. It's more of an opinion, right? I mean, I look at the productive, Coca-Cola, the recipe is a productive asset. I can generate something from it.
Domain property or not?
Well, I'm going to say intellectual property, yes.
Yeah.
It's a property right, but information, like you could trade on inside information and the price could go against you because it's an opinion about the value of the stock. And you may have a better opinion based on facts and circumstances, but is that really a property right in the sense we think about intellectual property?
I think that intellectual property, including trade secrets, are properly understood as property. And I say that because of the two features that I identified that I think are fundamental to what makes a thing propertizable. The fact that you can engage in exclusive use of the thing. If it's possible for you to engage in exclusive use of the thing, you can make that thing into property, and we do that with information all the time. And with trade secrets, for those when you become the law students, you'll learn that you don't get trade secret protection by just calling something your trade secret. You have to prove to courts that you are engaged in what I'm labeling broadly exclusive use by showing that the secret is invaluable, that it actually generates a benefit for your business, and you're engaged in the productive effort of keeping it secret. And that you engage in the productive effort of either creating it or you paid for it with your own cash and actually got permission to use it. But you have to show that you are engaged in the effort of keeping it secret. So to the extent that you can have information exclusively that makes it useful in part because it's exclusive, to me that allows trade secrets to be property. And I think Scott's right to point out that just because someone has information that other people don't have doesn't mean that they'll be able to make money with it. Lots of people have traded on inside information and lost money, including people who have gone to jail for the insider trading that they're going to jail for. There's
Double penalty. You lose money and you go to jail.
The movie Wall Street is based on a guy named Ivan Boesky who traded that way in 1985 or so, and he lost money on that trade. He lost millions of dollars on that trade. There's another guy. I think the last time the Supreme Court heard cases on insider trading, they involved a family and brothers named something Solomon. It involved two blood brothers and one brother-in-law. They lost money sometimes. Sometimes they made money. One of them was an investment banker and knew about certain deals that were about to come out and be reported. They traded on them. It was insider trading. Sometimes they lost money. So yes, you can lose with insider material information, but that doesn't stop the information from being someone's property.
So James, I have another question, but I'm going to go to you first and see if you want to interject one of your ideas or thoughts into the discussion.
Well, I mean, I think, I think Kevin raises some interesting points. Maybe this is a useful way to, reward employees or to pay suppliers. I think some of the things you said about maybe the risk involved in doing that, trading on so-called inside information, perhaps undermines those points a little bit, right? If you're paying the CEO or paying your suppliers, they'd probably rather, a risk-averse entity or person would probably rather have $1 million than a lottery ticket to maybe make $30 million. It depends on your parameters, but so I think that's one point. I think your observation that most market participants don't seem very put off by information asymmetry, at least in U.S. markets. I think if you look at other markets outside the U.S., you might have a different view in some places. But within the U.S., it doesn't seem to be a huge problem. People seem willing to play the game. Overall, people that invest in the stock market seem to do fairly well. They're not getting their returns eaten by nefarious insiders left and right. But at the same time, that's under the status quo, right? Where we have this sort of dual regime where it's not clear that you can really give permission to somebody to go and inside trade. I think that would be a risky thing to do, and most people wouldn't really want to do that. So I don't think it's possible to conclude based on the status quo what moving to this other system would look like. So maybe one refinement, if we were going to have a permission-based system, a property rights-based system where the the corporation or whomever the owner of the information is deemed to be can go and grant the right to trade on that. What sort of limits do we put on that? Does that mean that every time there's a stock buyback, it's every man and woman for himself and herself, because there's no limit on the ability to inside trade? You can put the full resources of the corporation behind it, and potentially expropriate all the value that would be
So
created.
what you're saying is the CEO buys a bunch of stock and then commits the firm to buy back the stock and rise the price, and so they're making decisions on both sides. Is that the issue?
Well, there's concerns about there's concerns about manipulating the firm's actual real-world operations too. I mean, Lucian Bebchuk raised that point decades ago. I don't think there's evidence of anybody ever tanking the firm in order to short sell it, right? But that would be a potential issue as well. But even if you just assume the firm's operations are what they are, is there any sort of limiting principle on how much we're going to allow firms and their designees to inside trade?
And me, right? Because I'm the only one advocating that we allow firms to authorize insider trading.
Well, you stepped into the role of Henry Manning, it seems like.
I did. And I also started my legal career at George Mason University, which is the law school that Henry Manning started. That is, I'm kind of heir to the throne, kind of, because no one else wants it. So, limits. Didn't say this. There are a few places in the law that I said that insider trading is a distant cousin of this thing called fraudulent non-disclosure. You can think of it as illegal secret keeping. There's only a handful of reasons why you might face legal liability, jail time, disgorgement of profits, or something else for keeping secrets. For the most part, privacy is like your right, and you're allowed to keep whatever secrets you want. And there's a handful of situations in which you might be able to face liability for keeping the secrets. And I am okay with a set of situations, all the situations under which people might historically face liability for non-disclosure. I'm okay with that applying to insider trading. The breach of the duty of loyalty is one of them, and another, there's like 5, is something called a fatal defect, where if you are selling someone a house and you know that the house is riddled with termites, you know that people don't want to buy houses riddled with termites, you have this obligation to tell them about the termites, otherwise the sale can be rescinded and the person can get their money back once they find out that you kept this from them, right? I think the way in which I think that can end up applying to insider trading is, while I'm generally okay with people being able to sell stock and short stock when they have knowledge of negative information ahead of others that's going to make the stock drop, I think I'd put the limit on it of if you know that the stock is going to somehow drop to 0, or you think that the stock is going to be delisted, maybe we can consider that a fatal defect, and you shouldn't be able to short the stock or sell the stock with that kind of knowledge. Otherwise, if you just know that earnings are lower than expected, and which will make the stock price drop, I consider that a normal part of stock ownership. Prices go up and down, bad things happen, stock prices decrease. It's a feature, not a bug of securities markets. And so for me, that's one place where I'd put a limit. As it relates to concerns about manipulation and other concerns about maybe created inefficiency because now managers and CEOs are distracted with wanting to manipulate stock prices to, even if it wouldn't be fraud in terms of price manipulation, maybe it would just be inefficient because instead of focusing on the product, like creating awesome phones, they're focusing on what will make the stock price jump in ways that let me generate profits. And therefore we should ban insider trading to stop that from happening and ban insider trading to stop the hiding and masking of manipulation. I don't like prophylactic law. I don't like the idea that you get to ban an activity out of a benign activity out of a concern that it might hopefully maybe prohibit a malignant activity. Instead, I like the idea that prosecutors and plaintiffs have to prove based on some standard of certainty that you've actually done the bad thing. Not that you've done something we know is fine, but we know that sometimes that comes along with bad things and we can't prove the bad thing, so we'll punish you for this. To me, it gets too much like Minority Report, and that bugs me. I might be okay with something like a rebuttable presumption, especially with Congress. The idea that if you passed a law if you voted in favor of a law that you knew was gonna affect a particular industry in some way, and you traded ahead of that, you knew it was gonna destroy an industry, you short the industry, you know it was gonna benefit an industry, you buy stocks in that industry. I'm okay with a rebuttable presumption that they have to disgorge those profits, unless they can prove that it was somehow disconnected from the vote that they had in Congress. But otherwise, I'm not for banning and creating prophylaxis to try and stop manipulation and bad acts.
Does anybody have a question on insider trading? Yeah.
So the question I have is, it seems like kind of part of the back and forth there is kind of thinking of this as a kind of all or nothing issue, of like our stocks. Oh, thanks.
So just for everybody quickly, the mic doesn't actually project.
Check.
Just for the recording, so if you don't mind.
Okay. I guess my question is, so if, let's say hypothetically, we agree with James that it would dissuade people from entering the market, like couldn't we actually just test that by having, allowing for some companies to sell stocks along with contractual agreements that say something like our managers are allowed to trade on whatever secret information they want, and having other companies trade stocks on the basis of we're going to sell stocks, but our managers are not allowed to retain any kind of hidden information. And then you could effectively have a competition between firms that are selling stocks on that basis and firms that are not selling stocks on that basis. And you can actually test this idea of, does it actually dissuade people
So every
from purchasing
Thursday
securities?
through Saturday, or every Wednesday through Friday, firms A through M can engage in insider trading, and other ones can't. So we run an experiment to see whether or not there's an effect in the pilot study.
Or it wouldn't even have to be time-based. It could just, you could in real time just have a society with both types of firms, or both types of stocks, if you will. So there could be some stocks that are, you could call them like inside trading permission stocks, and then you could have some stocks that are only public information stocks.
Scott, can I take this one?
Yeah, please go for it.
So I think that's a good idea, to be clear. Let's talk about what we could do, what we could actually do, and what the academic literature has found, because I've done some of this work. Let's make the experiment a little bit more modest, right, so that we can actually implement it in the world. And rather than say, okay, firm A, you can engage in insider trading, and firm B, you can't. Let's allow firms to put in their own insider trading policy. So one of the things that I don't think is quite appreciated by retail is that firms have various policies that would prevent, prophylactic measures that would prevent insider trading by their executives. So an example is a blackout window before an earnings announcement. So the blackout window might say, thou shalt not trade 30 days before the earnings announcement. Or thou shalt not trade 2 days before the earnings announcement. Or you must get your general counsel to approve the trades before you trade. Or you must use a pre-planned trade. So you say, I want to sell stock, but you can't sell it for 3 months until after 3 months have elapsed before the sale comes. And what research has found is that those firms that put in place, let's call it laxer policies, weaker blackouts, do not have GC pre-approval requirements, are less liquid. Now, the research is, so you might say, okay, well, that's consistent with a lack of investor participation, widening of bid-ask spreads because people are anticipating, insiders might come to the market. An alternative interpretation of that is that no, the types of companies that put in place sort of these weaker policies are just younger, less experienced, maybe biotech, as opposed to, McDonald's or Coke or CEO or Pepsi, where they pay, millions and millions for, in-house and outside legal counsel. But there is definitely evidence that there is a difference in participation and information asymmetry among those two types of firms, depending on the level of the extent to which they restrict.
So Dan is saying
insider
there's
trading.
natural experiments based on the self-selection property that shows what you're saying. But if you really want to know, the proof in the pudding is to run an experiment where you force companies that wouldn't otherwise do it to make Coke permit insider trading to see what the effect would be, right?
Right. Yeah. So I'm in the endogenous world where there's self-selection and there's no as if random variation, and we don't get to choose. We just get to observe what patterns we see in the data.
I was once on a panel with somebody who said, we don't know if smoking actually causes cancer because we never made people smoke that didn't want to smoke. Now, that was the extreme view, but...
Let me, in case you wanted to do some of the work, because you could do some of it. Well, the one straightforward way to do it in my mind is to allow the exchanges to implement different rules and to see what happens if one exchange adopts a insider trading is okay rule and others don't. At the state level, Delaware is the state where most corporations are incorporated, and then and so they have the Delaware statute on corporate law, and then there's this thing called the Model Business Corporation Act, which the vast majority of other states have adopted as their way to regulate corporations and decide what they can and can't do. Both of them have a provision in it that says that you can include in the Articles of Incorporation or bylaws something that says that employees can be authorized to take advantage of business opportunities on some categorical basis, as opposed to having to have them approved case by case. That's the kind of thing that you would have to have happen in order to have permission to engage in insider trading. Because if I'm saying that in order to use the company's assets, you need informed consent, let's say that someone decides that what you need is the consent of the shareholders. If you go to the shareholders on a case-by-case basis to get their consent about this insider information, you tell them the thing and the price goes up, and so you can't benefit from the information advantage. You would need categorical consent to engage in insider trading, and corporate statutes let you do that. So you'd have to see which encourage companies to adopt them. That's another way to do it. Two other things. There's a thing called Section 16B. It prohibits short swing profits. It's the closest thing in the statute that the current federal securities regulation that looks like an explicit attempt to ban something like insider trading. There are other explicit things that punish insider trading, but without telling you what insider trading is or telling you that it's illegal. But the one thing that explicitly tries to ban something like insider trading bans short swing profits. It says that if you're a director or officer or you own more than 10% of the voting stock of the company, you can't buy and sell stock within a 6-month window, and you can't sell and buy stock within a 6-month window. That's how you short stock, making money from the stock price going down. For lots of companies going through mergers, they usually have to get shareholders to authorize the merger. Companies often have within their merger agreements some kind of Section 16B waiver, meaning the board of directors who just told you that you should authorize this merger, a bunch of us probably bought and sold stock within the last 3 months, and we're asking you to approve this merger that's going to make us have to give up some stock in exchange for another stock, which would look like short swing profits. So we need you to give us permission to have the short swing profits as a part of authorizing the merger. I've not heard yet of any merger that did not go through because the shareholders were like, well, not those short swing profits, though. You got to get rid of that provision. And so you do have like a body, an incredibly rich body of evidence of shareholders authorizing something that looks like insider trading by essentially letting people keep their short swing profits.
Well, also just to piggyback on that, an interesting question is if these companies have these policies and they put in place these policies on the short swing rule, or they waive the short swing rule, who enforces those policies?
Which ones? The short swing one can only be enforced by shareholders. The rest are mostly enforced by the Securities and Exchange Commission and others.
So like the GC pre-approval, the blackout window, all of those are enforced by the company. So they're not enforced by the SEC. Now the SEC may use violations as evidence that you were doing something illicit, but in and of itself, it's up to the company to enforce it. What is particularly frustrating, and so, I'm kind of with James on the status quo of the law. What I am not okay with is the status quo of enforcement. So, and this is more for the law professors to piggyback on. Let's say I'm a shareholder in a company and the CEO violates the short swing rule. Can I sue the company and compel the CEO to disgorge?
Yep.
Right, as a derivative suit?
Period. It's effectively a derivative suit, and what that means is, to the extent that the corporation is a legal person, if anyone hurts the corporation, It sues in its own name. Yes, it's the board of directors bringing the suit or the general counsel, but the shareholders don't get to bring lawsuits on behalf of the corporation, except for in special circumstances, which we call derivative suits. It's effectively a derivative suit without it being called one. And only either it's going to be the corporation that brings it, but the shareholders are allowed to do so as well.
And do I have to worry about demand futility?
What do you mean?
So do I have to show that a majority of the board was engaged in the behavior, benefited from it?
No, because it is the thing that I like. It's a rebuttable presumption. By presumption, generating short swing profits is wrong, and you have to give them up as soon as the corporation or one of the shareholders comes and asks through a legal proceeding for you to give them up. You don't have to, under other forms of corporate law at the state level, you have to prove that you deserve to take power from the board of directors to have this lawsuit, bring a lawsuit that they didn't want to bring. But you don't have to do that. I don't think you have to do that with 16B.
Okay. So, I mean, from my perspective, and you can look at this in the data, short swing violations are quite frequent. And they're not trivial sums of money either. And you definitely see short swing rules, and you don't see people saying, hey, we're disgorging. You don't see the SEC compelling disgorgement.
Is that a measurement issue? People they're just not sophisticated enough to see them because of the way they're enacted? Is it once you write your paper and show this, then all of a sudden we're going to see these derivative lawsuits?
No, so I guess the open question is do you have to overcome demand futility or not? So demand futility, for those of you that don't know, is, and you guys, the lawyers can correct me, is can you show that you have a majority of the board that benefited from the action or is otherwise involved?
No, it's a case-by-case basis. It's like one individual generates short swing profits. You get to bring a suit as a shareholder that makes them give up the profits and give it to the company.
Okay.
Yeah.
Well, if you're a plaintiff lawyer and you're watching this, give me a call. I can give you a lot of short swing violation data.
For price.
I worry a lot about contracts in which you let your officers, CEO and high officers, have insider trading information, in part because I don't think anybody knows a thing about anything. The future is very hard to predict because it has not happened yet. And who knows what this ability to trade on insider information is going to be worth beforehand. It's pure crapshoot. Nobody knows at all. I might contrast, for instance, paying your CEO with stock, especially stock of a publicly traded company. Now, nobody in the world knows what the future is going to be, but at least you have hundreds upon hundreds of well-trained investors who are very greedy and absorbing all the information they can get, or at least that it is worth paying for that amount. And so we know a price when you give $100 worth of stock to your CEO. Nobody knows what that's going to be worth, notwithstanding all the claims. The future can't be predicted. It's always wrong. It will not come out to be 100 discounted present value of the cash flow. It'll be a volatility up and down. But nonetheless, with so many people bidding on it, we have a great deal of confidence that you can, in fact, properly give $100 to your CEO with confidence that nobody's being treated. But on the other hand, supposing I got a stock that is going to be worth $10 billion because it fits perfectly into Google's system, make them far more than $10 million if they want it. And if, who knows? In fact, let's claim it's really speculative. This stock as a whole is worth $1 million because it's unlikely that Google, in fact, will pick up this little gadget that fits into their thing. So the people who go into it are kind of a crapshoot. If we're having many bidders on that possibility of $10 billion profit, then I want to say that's great. But if we don't have many bidders, then you have nothing but insiders giving themselves high compensation on the basis of totally unknown future, and you cannot say that there is any such thing as a fair trade by two informed investors. Investors need to be treated lovingly. They put in their money only because they had a good shot at $10 billion. And if you're having the CEO who's going to strip off all of the good news Then the answer is you don't treat them fair, and you don't have a stock market anymore. And this insider deal between top management and who's on the other side? Oh, top management. This insider deal between top management and top management on the basis of totally unknowable information about the future. I'll do it if there's a public market. The stock, you can give them a share of the future, but not on anything else.
I think, so if I could, that brings up actually 2 points that I wanted to put to you as well. So I'll jump on that question and channel it a little bit. So one is this issue of that it might not be great compensation, right? If you're for paying a risk-averse executive, it might not be a great way of compensating that person. And I think we talked about that already. The second issue, though, that Calvin mentioned is one of price discovery, right? That it is useful. It's actually more useful to get this information out into the market in some way in order to enable the price discovery process to occur. And that does bring up the question of, is the status quo prohibiting those sorts of useful price discovery mechanisms from occurring? And I know that we talked about a couple of things, like regulation FD, things like the warehousing, M&A warehousing that you mentioned, where companies go and will give information to other potential allies in terms of acquiring a target, right? And all those things conceivably enable this difficult process of price discovery to occur. And this seems like a potential cost of the current system that may be dissuaded by the law as it currently is.
And therefore, how do I respond to the idea that maybe insider trading should be better because it helps to make the markets more efficient in that specific way?
Well, that would be one thing, yeah.
Or what you wanted me to just give my thoughts on it, or address a specific thing?
Well, what is it about the current law that is keeping those useful processes from occurring?
The way there's a theory of efficient capital markets, and people often think we need capital markets to be efficient in order for both capital to flow into those markets and for society at large to become wealthier and better, right? And for capital markets to be efficient, by definition, it means that the prices in those markets fully reflect all available information. And people assume that prices will reflect all available information in one of two ways. Either you have mandatory disclosure regimes, everyone has the information, and now everyone's thinking about the information as they decide to buy or sell the stock, or you have people who know things that others don't, who are buying and selling the stock based on what they know, and it's the trading activity that makes the stock reflect the information, as opposed to everyone having the information and averaging out their thoughts and values about the information, and that somehow getting back into the stock through that trading after the fact, right? I do think to whatever extent that's useful, and it's useful in a couple of different ways. The way in which I think that's useful and that the current laws stop that from happening is that sometimes a company has made some kind of really incredible discovery, but they have to keep it secret for some period of time before they can tell everyone. And there's usefulness in it being secret, but you could benefit the world by letting them know something good's coming, that's useful for the investors that are out there, right? And the way it happens very frequently in cases is that there's like a mining company of one kind or another who discovers a certain set of minerals, and as they quietly buy up the mineral rights, because they don't want their competitors in the same industry to outbid them, they don't want the sellers of the mineral rights to raise their prices dramatically. As they quietly buy up the mineral rights, oftentimes their employees will quietly buy up the company stock. And if they buy enough, this company stock price starts to go up. And the world at large, because of that increase in demand in the company stock, the world at large knows something good's happening, but they don't know specifically what it is, so they can't get in the way of the company doing the good thing. So that's a beneficial thing that I think is undermined by the prohibition on insider trading. That said, the most radical thing I'll tell you today is that I don't think correct prices exist, or incorrect prices, and therefore there is no unfairness in the insiders buying at what you think is mispriced, a mispriced stock or something to that effect. I brought up earlier this concept of a defective product, the idea that a house full of termites isn't the kind of thing a person wants, and it's kind of like lemon laws. If you're selling junk to someone and telling them it's an effective thing, it's a kind of fraud. And I think, in a way, insider trading laws are this weird inverse of that, like the Alice in Wonderland version, where instead of the underlying stock being thought of as defective, maybe it doesn't have the voting rights you expect, or it won't be resellable in the same markets you think it's resellable in. Instead, it's the price that's defective. Somehow, you not putting the information out there first makes the price defective, and now you're selling someone something that's broken, but not broken from the product end, from the price end. I don't think there's any such thing as a correct price. I think that there is a cause and effect relationship between changes in supply and demand and how the information about changes in supply and demand affect prices. But the price is what it is. Instead, I think what makes more sense is to say that a person, an investor, can be correct or incorrect in their prediction of price change. A person can be correct or incorrect in their explanation of how a price got to where it is, but the price just is what it is. And sometimes the price will be distorted because of insider activity. Sometimes the price will be distorted because of government actions. Sometimes the price will be distorted because there's a pandemic and now people don't know what to do, so supply and demand just changes in a weird way, or there's meme trading happening, but the price simply is what it is. And so I don't think you can sell a lemon or engage in unfairness by buying at the wrong price as an insider.
Let me just piggyback on that and to go back to something you said earlier. And Scott may actually have some information about this. Were you at the SEC during the Edgar hack?
I was.
Okay, so for those of you that don't know, Russian or Ukrainian?
I'm not saying.
All right, Russian or Ukrainian hackers breached the SEC's Edgar portal. Everyone know what Edgar is? You know where they put, okay, so Edgar is the SEC portal where they put up the 10Ks, the annual reports, the 10Qs, the earnings announcements. And so what was happening is that the Russian hackers were getting the earnings announcements before those earnings announcements were being publicly disseminated. So they literally had the news that was going to come out of the market before it came out. So an interesting question is, if you know what the company's earnings is going to be with certainty, right, and it's clearly misappropriation, nobody's questioning that, how much money could you make? Because you don't know how the market's going to react. All you know what the earnings number is going to be. And so what the SEC did in trying to establish that there was illicit activity was they calculated something known as the win rate, where they took the hackers or the associates of the hackers' trading activity that would occur not around the earnings announcement, and they looked at the percentage of times that the trades won, meaning they outperformed, made money or outperformed some benchmark. And they looked at the win rate for the trades that occurred around the earnings announcement. And the win rate was not, 99%, right? It was, I think, like in the 70s or 80s. And so the question is, when we talk about compensation risk adverse investors and, well, you don't know for sure you're going to be able to make money on it, that's true, but to make money, as any hedge fund manager would tell you, they don't have to be right. They only need to be right 51% of the time to make money.
They just need a good information ratio.
That's right. And so the win rate basically shows that, this information is still valuable, even if it doesn't perfectly predict price.
This actually brings up an interesting point in that the Ukrainians, if they were Ukrainians, the way they made money is not by trading, but by selling it to others who did make the money. So that's how they generated the profit. And those they sold the money to, the SEC went after and struggled, I think it's still in the court systems, proving that they engaged in insider trading because there was no smoking gun email. Right? There was nothing that tied the Ukrainians to these hedge funds and the Virgin Islands. And the SEC, even though they could show probabilistically that you would more likely get struck by lightning 3 times and to earn these returns, that wasn't enough, or it's not perceived as being enough to actually make a case. And it's actually open right now, and I'll let in terms of what is evidence that would bring a case that would win in the courts. And I remember I talked to the press about this after I left, off the record, but it is still an open question.
Yeah, I mean, I think it speaks to, I'm somewhat opinionated on this, the sad state of the courts and the legal system. Like, if we have a game of roulette and the person goes to the roulette table 100 times and wins 90% of the time, do we feel comfortable letting that case of cheating advance in the court system? Or should we throw it out without discovery under the notion that, well, you don't have any actual emails? And so it's not just this Edgar hack. There was an interesting case that the SEC just lost. In fact, it got dismissed. I think it was in either West Virginia or Virginia, where brother-in-law of an executive was trading in securities of the executive's company occasionally over time. And then one day, after talking with the brother-in-law, soon after talking with the brother-in-law, decided that they were going to take out a car loan, borrow against the car, liquidate all their retirement savings, and actually get out a home equity loan and go all in on out-of-the-money options on that company's stock. That wasn't enough to convince the judge to get to discovery. And so in that particular case, the judge threw it out by basically saying, you do not have a smoking gun, I see no emails, I see no documents, all I see is this, for lack of a better term, a coincidence of a close proximity between trading and a phone call. And yes, I grant that it's abnormal trading, but that's not enough. And I think that's problematic for a large number of reasons.
I want to jump in, and I like the metaphor. It lets me get to what to me is the most serious point of what's wrong with prohibiting insider trading. This metaphor that you have someone cheating at the roulette table, or you have someone cheating at the casino. For me, the most problematic part of insider trading is that we are essentially taking a bunch of behaviors and activities that are seen as perfectly healthy and benign in every other industry and in every other practice, even sometimes in securities markets, having an information advantage, and we're putting people in jail for that thing. And we are treating virtuous, healthy, upright, and upstanding stock market activity as something that's supposed to look like gambling. If you make money in the stock markets, people want it to look like you're winning at poker. They're against the idea that you buy information that others that don't have the way you would do in every other business. Franchising, in addition to Coca-Cola having its trade secrets and making its money itself by having its secret recipe, one of the things they do is license the information to bottlers who are not exactly a part of their company, and they get to generate profits in that way. One of the things that most franchises do, McDonald's, Burger King, Wendy's, Five Guys, Raising Cane's, is that they have trade secrets and they license the information to their franchisees so that they can make money, both the franchisees and the franchisors, by using the trade secrets in their individual practices. It's normal. But having an information advantage in securities markets, that's weird because it doesn't look enough like poker or Russian roulette or any other kind of gambling.
Yeah, in fairness, I don't think it's that. I think what it is that whose information belong to, and is that person contracting? And so that's why I gave that's why I gave the example at the beginning. If the CEO in the firm is contracted over the information and shareholders are aware of it, then that's one thing. It's another thing when somebody's actually stealing the information from the company or from the SEC and then trading on that information. It's a question of how they come by the information, not the fact that there's information asymmetry, not the fact that they win 100% of the time, but where they got the information from.
We didn't get your answer to the question, is it okay for the company to license the CEO to trade on the information? Yes or no? No, not you, this guy.
From a property rights perspective.
No. You, the guy who wants to control policy into the future. Not you, not in the sense that that's what you want, but I'm saying.
Do you want the academic answer or the Dan is king for the day?
Dan is king for the day answer. That's the answer I want.
No, absolutely not.
Then for you, it's not about theft. If the company can't license the CEO to trade on the information, then it's not about theft for you. It's about something else.
Look, I agree.
Then let's not say it's about theft. It's about information inequality.
There are two things that it's about. One is theft, and one is market efficiency and participation in healthy markets. I mean, James gave the precise example. There are countries where insider trading is actually legal. So you don't have to run the experiment within the US. You can go to various countries. There was an academic article published in the Journal of Finance, where they actually went to Mexico and they looked at the earnings announcement returns in Mexico, way back in like the 80s or the 90s. What do you think the earnings announcement returns in Mexico were? Nothing happened. No volatility, no price movements, nothing. Why? Well, insider trading's legal. Now, what kind of stock market does Mexico have? Right? So if you look at these, there's an endogeneity issue. We would say it's simultaneous. It's simultaneously determined. A lot of the countries where the insider trading rules are not enforced or are incredibly weak or don't exist tend to be really poorly developed markets. And we can ask the question, are they poorly developed because they allow for insider trading, or do they allow for insider trading because they're poorly developed and they don't have sort of the institutions? But this notion that, I'm with James, this notion that if we contract, the market's going to retain its level of efficiency, I think all the evidence suggests that retail participation, institutional participation will just evaporate.
I think you have to ignore the evidence before 1960 to believe that. And I say that because insider trading was not illegal in the United States until 1960.
I don't want to go back to 1960 markets.
We had a robust stock market before 1960. We had one of the most advanced economies in the world before 1960, and that is including before World War II and when we supposedly only became wealthy because Europe was destroyed. We've had a robust stock market for a very long time, but we've only been prohibiting insider trading since 1960. Greg, because he's been going for a while.
So one thing I don't understand about this issue is why it's a legal issue, why it's an issue of law at all. That is, there are stock exchanges. The stock exchanges could have whatever rules they want for how things get traded on them, or could have adopted an anti-insider trading rule to list on the NYSE before there was a law passed. This isn't like that's how it should have happened or something, but just like why didn't that happen? Why was it handled or thought it needed to be handled through laws against insider trading rather than either companies adopting this in their rules or exchanges? And this then applies to cases like Mexico too. If the Mexican stock exchange is suffering because they don't have insider trade, insider trading can be done there, why don't the exchanges, certain clearinghouses, why aren't there private actors who do it? Is it that there's no good enforcement mechanism, or why can't it just be handled through contract?
Okay, before everybody answers, I'm going to admit that I've been a poor moderator because the panel ended 4 minutes ago. But can we do a lightning round answer? Anyone wants to answer that very deep question?
Yeah, I think part of it is an agency problem between who controls the exchanges and who controls the companies. And the other part is an equilibrium issue in terms of, does it make sense for one company to have rules if none of the other companies do, or if it's just a cultural norm within the country? So do I think that Mexico would be better off with insider trading rules? I have no idea, to be clear, whether it would benefit Mexico or not. All I can do is look at the data and say, this is the patterns that you see when you don't have these rules. And then the question is the absence of the rules causing those changes in the market, or is it the market that causes that? But I do think the agency problems here are rampant, because in the US, the SEC doesn't require the companies to have the insider trading policies. It is the exchanges that require the insider trading policies. And interestingly enough, they don't specify what the contents of those policies are. They don't say you must have a blackout window, because there are companies on NASDAQ, God rest their soul, that do not have a trading blackout window.
It's a long, complicated answer that amounts to something like, somewhere in the 1920s, people rejected the idea that everyone has an inalienable right to the pursuit of happiness, and instead what mattered for law and regulation at the federal level was something like, does it benefit the public interest? And so the way you ran your company and the way you ran your exchange and the way you ran the other thing was no longer about, the laws controlling it were no longer about facilitating contracts and the enforcement of contracts and the protection of property rights. It's what will benefit society. And this isn't just about something about economic inequality and wealth redistribution. There were people who wanted society to be wealthier and decided that, like, experts coming up with the rules that everyone has to follow is the best way to achieve that. Our federal security statutes are an outgrowth of that. They're one of the few things to not get struck down. I think a lot of things got pared back in the 80s, but not the securities controls. And so to the extent that people are trying to create economic efficiency for society at large or to increase the public welfare, that's why this is being handled through statutes and SEC regs and not through the companies and the exchanges. And one last thing, there's this weird double-speak thing happening in our federal securities law. There's a bunch of organizations like the New York Stock Exchange and NASDAQ that are identified as self-regulatory organizations because they're supposedly private organizations coming up with their own rules on how to keep the market efficient and safe and fair. But they can only adopt the rules that the Securities and Exchange Commission says that they can adopt. So it's not really self-regulatory. So that's the reason.
Okay, so thanks everybody for coming. If you want to chat with these guys some more, come on up here, but we appreciate you being here.